Pascal. You are now rocking with that dude Pascal. We be going wild, Haitian in the building, so original. Got the haters catching feelings. Get your hands up to the ceiling and keep them held high, cause St. Louis isn't ready. Forget about it, goodbye. Hold up, we just saying hi. Five somebody, rise up. Weekdays, catch us live, somebody. Let's go.
Good afternoon. Good evening and good morning, everybody. Welcome to the Pascal Show. Hope you guys are all doing well out there. I'm serious. I hope you guys are doing well. You know, it's Tuesday. You know, some people say it's Monday part 2. I say it's just another day to kick the day in the, kick the week in the butt. You know, accomplish all those things that you wanted to accomplish. You know what I mean? You still got time today to accomplish anything that you want to get accomplished today. But anyway, sorry for the delay. We had a little bit of a technical difficulty. Fixed it. So we're good now. But I'm very excited because, you know, we got a good friend of ours back on the show. And of course, you know, I got, like I've said a million times before, I got a lot of questiones. I got a lot of questions. Lot of questions. So get ready for a very informative. You know who we got coming onto the show. It's going to be an informative one, okay? So get in, get comfortable, okay? And real quick, do me a favor, hit that like button down below. You know, we got to do the housekeeping stuff. I know it's boring, okay? But hit that like button down below, all right? Send it past 300 likes as you start to file in. And then, of course, do not forget, if this is your first time checking out this channel, please hit that subscribe button, annihilate it, nuke it out of the screen. But if you break the screen, don't blame me. Don't send me the bill, okay? Just pay it yourself. You hit the screen too hard, okay? But it'd be great to have you part of the Pascal Show family. Make sure you hit that notification bell, set it to all so that you know when I go live, when I upload anything, because it can be very, very random, okay? So we got to get into some things. So let's hop right into it. Now, you guys already know we've been talking about, everybody and their mama has been talking about this whole subpoena for Bethany Funk. Okay, funky, I don't know what it is. All I know is it's funk, okay? Or at least I'm going to say funk from this point on. There is some allegations, or there is some information, okay, from a private investigator that was on behalf of investigating on behalf of Bryan Kohberger, that is now coming out saying that she heard and saw some things that could very, very well possibly make this man innocent. Exculpatory evidence that could make this man possibly walk free. Now, the reason why I'm asking all this stuff and we're talking about it is because we have a very wonderful guest. She's been on the show a million times before, but it's great to have her back on. Andrea Burkhart, attorney at large. Okay. Thank you so much for being here. How you doing, sweetheart?
I'm doing great. Thanks so much for having me back.
Of course. You always got a place here on the show. So it's great to have you here. There's a lot going on here. And the world is losing its, the true crime world. Let me correct that. The true crime corner of the world is kind of going berserk right now because of these new documents that have been released about this subpoena with Bethany Funk, trying to bring her in as a material witness on behalf of Bryan Kohberger. And so a lot of people are losing their minds, and there's a lot of people that have a lot of questions, including myself, on what could this possibly mean. But before we jump into everything, right, before we jump into all of this, get down to the nitty gritty, I need to know, were you shocked when you saw this information a couple days ago?
I was not shocked, but I was definitely, it caught my attention for sure. This is not exactly the most ordinary course of events. It would not have surprised me at all if the state had been going to get a material witness warrant or an out-of-state subpoena for a witness like Bethany Funk, just because you kind of expect that to be routine. She was obviously there, has obviously spoken to police. And you just kind of assume that she would be a witness for the state, but apparently that's not the case. So what got my attention was her trying to quash it, because that is quite unusual. That obviously indicates that she's not interested in cooperating with this process. She really doesn't want to be a part of it. So then once we learned that, it's Bryan Kohberger who is subpoenaing her, that reluctance perhaps becomes a little bit more clear.
Right. Now, I and of course we're going to pull up the whole motion to quash here in just a minute. But okay, aside from your own professional opinion, okay, just from your own gut. So I'm just asking you to, as a regular civilian, okay, you're not wearing the Esquire hat right now. Do you think this is the right move, personally, if to quash this foreign subpoena?
I mean, how do I take my lawyer hat off on this one?
I know that's tough. I know that's tough, but I got to ask you, you know what I'm saying? Just from that end, just from that end.
I can understand on a personal level for so many reasons why she would not want to be a part of it, particularly if, as is kind of being implied by this process, it sounds like the information that she may have available is going to benefit Bryan Kohberger and not the state. I could see her, obviously being reluctant to volunteer that, particularly if she otherwise, has reasons to believe that it might have been Kohberger that did it.
Now, I do. Okay. So outside of, because that was kind of a hat, you're wearing the hat still. You were wearing the hat.
I can't take it off.
You were still wearing that doggone hat, but it's fine. I know it's hard to turn it off, especially this is what you do every day. But let me just pull this up really quick so that we can see this together. Now, this motion to quash paperwork, okay, these documents here. All right. So motion to quash foreign subpoena. Is this normal? Would you say this is traditional? This is a normal thing that people do, or is this kind of unprecedented?
It's not unprecedented, but it definitely tells you this is not a cooperative witness. And so from my perspective, that's kind of telling because as an attorney, I don't typically want to call a non-cooperative witness if I don't have to. They can be very unpredictable. They're not friendly to you. They don't want to give you the information that you're looking for. And so you don't always know what you're going to get with that situation. And so that does tend to suggest that whatever information she does have that they have on record that they can, pin her down to with a police interview or a recorded statement or something like that, is significant enough in their view that it's worth the risk of her otherwise being predictable and possibly not very cooperative.
Now, okay, so you're basically saying in layman's terms that she may know something that could help. You feel that by her doing this very motion to quash, it's kind of like she's showing her hand, like she's almost admitting that she knows something that she doesn't want to admit that she knows. Does that make sense?
I don't know. Yeah, I understand what you're saying. I don't know that that's necessarily her perspective. I certainly think the defense thinks that. She may not think that. That may be part of her reason for why she doesn't want to be involved. She thinks, I don't actually, maybe to her, in her mind, it's like, I don't actually know anything. So why should I have to, be pulled all the way back to Idaho? Why should I have to face this guy that maybe I'm terrified of? Maybe I don't want to be part of this very public process that, quite frankly, has been a little bit difficult on some of the people who have been at the center of this case. So I don't know that it necessarily tells us anything about what her actual knowledge is, but it speaks volumes as to her flat not wanting to participate.
Could it just be flat out fear? Could it just be that?
Absolutely. It could be anything. It could be just, it could be fear. It could just be, I'm trying to move on with my life. I don't want to deal with this anymore. I don't want to revisit this trauma. It could be any of those things. Interesting.
Because I know that there's a lot of people that are wondering about this. And I feel like a lot of people out here are thinking, oh, she must know. She definitely knows something, right? She got to know something. But, when we look at something like, let's look at this, the private investigators list of reasons to bring her in. Okay. Especially near the end at the bottom here. Let me just blow this up a little bit more so everybody can see it a little bit better. Okay. So now, and actually, well, no, this is kind of together, so I'm gonna go with it. So let's just go with it. Okay, we're gonna do it live. Okay, so Bethany Funk was interviewed by police on several occasions. She disclosed things she heard and things she saw. Okay, now one thing I do have to ask, and I was asking this a billion times, and I know, guys, I already know y'all are gonna be like, hold on, before you jump down my throat, let me ask the professional here. Okay, why wasn't anything about BF, about Bethany Funk, written in that probable cause affidavit? We looked at that probable cause affidavit. It says DM and BF. Everything we hear about DM is, I mean, not everything, but there's a lot that's being said by DM, but nothing by Bethany Funk. How could that possibly happen, and why did it?
Well, that is kind of the $1 million question, and it's certainly going to be related to what actual information does she have, what has she actually told police, and how does that weigh in the overall evaluation of the evidence that led to that initial probable cause determination for the arrest. Police are at least. Well, let me backpedal on this. There is kind of some debate over the extent to which potentially exculpatory information has to be included in an affidavit like this. I mean the original probable cause affidavit. We saw, for example, they had included some language in the search warrant affidavit over in Whitman County where they specifically disclaimed, they said, we're putting the DNA in here. I don't think it's potentially exculpatory, but I've included everything I think is potentially exculpatory. And even if this turns out to not be admissible, therefore, don't consider it. So there has been kind of this implication from the police that they have included everything that they think is potentially exculpatory. But that's almost, practically speaking, never going to be possible. And that's just because there are always even just small conflicts between how people remember things, exactly how people see and report things, just all kinds of little details that can potentially be messy. And just because we're human and we make human errors. So it's not feasible for them to include absolutely anything and everything in the probable cause affidavit. That would tend to suggest one of two things. Either Bethany Funk's information is not really so significant, at least not in the eyes of law enforcement. There is a disagreement between Bryan Kohberger's team and law enforcement as to how significant her information is. The other possibility, of course, is that it was suppressed deliberately by law enforcement. To me, you always have to consider that as a possibility, but it just does seem unlikely given that it's almost uncertain, almost a certainty that at some point somebody's going to talk to her and find out what she knows, so it's going to come to light. It's not going to be the kind of thing that you can hide forever. So I think in all likelihood, it's probably small pieces of information that may be exculpatory in kind of limited respects, or they may cast doubt on some aspects of the case. But not, so overwhelming that the law enforcement, considered it significant enough that they needed it in that affidavit.
But then that doesn't make sense to me, though, right? Because if the private investigator is sitting here saying, and I quote here, saying something along the lines of, let's see, she has information material to the charges against Mr. Kohberger. Portions of the information Ms. Funk has is exculpatory to the defendant. Her information is unique to her experiences and cannot be provided by another witness. That to me seems like, I feel like that's setting the documents on fire, in my personal opinion. So if you're going to sit there, not you, but in general, rhetorically, if you're going to sit there and say, oh, they don't put everything in there and whatnot, why would law enforcement look over basically glance over information from Bethany that could be huge information that was never put in that probable cause affidavit. It just doesn't seem to make sense. Now, another part of it is, could that be the Giglio or the Brady Gigolo, whatever it's called? Mm-hmm. Could it be that too? Like, you see what I'm saying? Like, why wouldn't they have that information in that probable cause affidavit?
Sure.
And well, of course, so you got this private investigator able to see this information, finding this information, and it not even one sentence in the probable cause or anywhere else has ever been reported. It just doesn't seem to make sense why they would look over maybe a huge piece of information here.
Mm-hmm. Well, I have a couple of thoughts about it. So first off, when they're using the term exculpatory, we often see that word and we think instantly it like is directly proving his innocence or something like that. And when they're using exculpatory in this context, that it's extremely broad. It's not just limited to that, game-changing type of information. It can be something that impeaches another witness. It can be something that is potentially contradictory with other evidence. It doesn't say that her information is like highly reliable, for one thing, so this is kind of an example of how the perspectives perhaps on the situation could be a little bit different. For example, hypothetically, maybe Bethany Funk told law enforcement something about her own timeline, and her timeline would conflict with maybe Dylan Mortenson's timeline. So there would be a potential impeachment there, or her timeline would undermine the timeline of the crime, which would be very significant because, of course, it's the convergence of the vehicle being in the place at that particular time frame, the observations of Dylan Mortenson, and all of this stuff happening at the same time is really what points the finger at Bryan Kohberger. So if that piece falls apart, then they could have a big problem. But the fact that Bethany has said that, again, hypothetically, given that information, doesn't mean that her information is correct. It's possible that police can go back after the fact and be like, no, that couldn't have been the case because, for example, we looked at her TikTok or we looked at her social media and it doesn't line up with the information that we've told her. So her credibility is and her veracity is still at issue. The fact that she may have information that is exculpatory does not necessarily mean that information is highly reliable, highly believable, such that police would consider it, so important that they need to put it in the probable cause affidavit. They could conclude to themselves, okay, yeah, she told us this, but we're not buying it for whatever reason. So we're not going to rely on that.
Yeah, interesting, because I obviously when you see this, and this is from the private investigator, and I mean, anything's possible. This private investigator could be looking for anything and found out that, I don't know, she heard a bump, a thump in the night. Suddenly it's exculpatory. He's going to be exonerated off of this information. I mean, could it be that? I mean, could it really be that minuscule, that tiny?
It really could be that minuscule and tiny. Yeah, absolutely. We don't know. I mean, we don't know. But yes, it certainly could. I mean, I have to tell you that, yeah, the possibility that she has exculpatory information, it could be as big as, she saw somebody else in the house who doesn't look anything like Bryan Kohberger, in the same time frame. That would obviously be huge. Or it could be something as small as maybe she thought she had seen that knife in the house before,
Yeah, no, you got a point there. Real quick, I just want to do, we got some questions or, we got some comments and everything. But first, Tony, welcome to the family. Thank you so much for becoming a member. I really do appreciate it. Thank you so very much. Thank you. And just like Tony, you can easily hit that join button down below and become a member, support the channel. That would be greatly appreciated. But let's jump into some of these questions here really quick, because it's been rapid fire since we started. Have mercy. But it's never a dull moment with you, Andrea. Never a dull moment. Let's see. I think this is a question. Iris said, is it true judges don't like surprises and want to know all material evidence? Otherwise, it can be par received. I've never heard that before as well, but as a fraud against the court.
Mhm. Oh, this is maybe getting to the second thing I meant to say that I forgot to mention, because you had asked about the Brady Giglio stuff.
Yeah, the
And
gigolo.
is that potentially related? And my view is that no, it almost certainly is not related, for a couple of reasons. One, just because the affidavit indicates and implies that they already know what she told police. It's not an issue of, like police interviewed her and didn't disclose what she knew, and it turns out that was exculpatory. But the other reason is relating to what you're talking about with the probable cause affidavit. And, maybe they omitted this like highly exculpatory information from that. There's a different, I guess, magic word you're looking for that particular context. That one's called Franks. That's Franks versus Delaware. It is a specific U.S. Supreme Court case that deals with the process if there's an allegation that police have omitted material information from an application, a warrant application, or something along those lines. And so there's a process where you go through where there's a hearing on that and a determination, was it deliberate? Was it material? Was it exculpatory? That type of thing. So if something like that were of a concern, that's the word we would be saying. We would be saying Franks. So the Brady Giglio, I don't think is implicated by this. But to get back to kind of the broader question that's being asked, yeah, judges do not like being sandbagged. Okay, it tends to make them very unhappy when they're led, down a road that turns out to not be appropriate. It's not necessarily going to rise to the level of like someone's going to get criminally charged or someone's going to be held in contempt or anything like that. But it certainly is not the mood that you want to set with your court on a case of this magnitude.
Interesting. And yeah, I mean, you don't want to get the judge upset now. No. You don't want that. You don't want that.
Not ideal.
Nah, never ideal. Virginia said Bethany's timeline just doesn't seem very logical to me because it might be something else going on. What are your thoughts on that, actually? Because we've heard nothing about Bethany. There has been countless videos about Dylan and what did it take so long? I mean, I'm mocking even myself, okay? I've talked about it a million times. Why did it take so long? It was 6 hours to call the 5-0. What's up with that? Blah, blah, blah. We talked ad nauseum about Dylan, nothing about Bethany. What are your thoughts about that as far as her timeline, her narrative? I mean, is she? What are your thoughts on that? It's so
well,
strange to me.
we know very little. We know just very broad outlines from her, and so I mean, yes, there is this big gap in time that we have almost no information about. The gap in time between hearing these noises and the 4 to 4:30 time frame, and then 11 o'clock the next day. So yeah, that's a question that is natural to ask. Everybody wants to ask. It's the defense is certainly going to be asking about it. This affidavit from the private investigator, to me, is suggestive that might be part of what they're interested in, simply because they bothered to bring it up. She was present at the house 8 hours later when police were called, arrived on scene, and discovered the homicides.
Right.
If it was just about what she saw at night, then it's kind of, that's significant, in and of itself. If it's not relevant, what happened in that interim period, and then when the police showed up. Then why would you bother to bring it up in this affidavit where the whole point is to show that she's got material information
exactly
that has to do with the charges? So that could be a part of it. We just really don't know. Don't know.
Because to me, it doesn't make sense if she was like, "Yeah, I was there." Like, you know what I'm saying? Like, you're bringing her all the way out from Nevada, her in her nice safe place, her new safe place, far away from the nightmare that she went through, to walk into a courtroom on June 26th or 27th, 28th, however long the preliminary hearings are going to last for, to have her sit down and just say, yeah, I woke up, I walked out the front door, I saw a commotion going on outside and I saw nothing. They're willing to risk it all for that same narrative that we've all known so far. That's it.
I mean,
this could literally be a nothing burger. It could literally be nothing.
It could be nothing. It could be nothing.
Yeah, mercy.
Possible it could be nothing. I mean, again, you got to just come back to this is potentially a death penalty case. They're not going to leave any stone unturned. And so if there is any possibility that she could have information that could be helpful to them in any way at all, even if it's just to, plink at, small details in the case, because as we've talked about before, this is a circumstantial case. It's, not the strongest, not the weakest you've ever seen, but it is all circumstantial. And so if any of those connections between the time frame, the noises, the person seen in the house, the car parked outside, all of those things have to converge for there to be this strong suspicion of Bryan Kohberger. And so if any of that can be thrown out, that's you've got a pretty long way towards, undermining the probable cause that led to the charge in the first place. So it would not surprise me at all that they want to use every possible tool that is available, that is a resource to them. The fact that she was present at the time, I think, makes it, it's just, you can't get around that it's material, which is part of why, when it comes to this motion to quash, I don't think that there is much of a chance that that's going to be granted. I think it's almost certain she's going to be compelled to come to Idaho to testify. But yeah, what that ultimately translates into for the defense, it could be huge, but it could be nothing.
It could be absolutely nothing, which
could be absolutely nothing.
Precy just said this too. People on the Idaho M's subreddit say it's just a fishing expedition by Bryan's lawyer. Do you mind expanding? I know you just heard this, or maybe you've heard this phrase before. I don't know. Maybe this is something that you legals out here say all the time. I don't know. But do you mind expanding on this fishing expedition type of thing? I mean, from my understanding, it seems like they're just trying to find everything and anything possible that they can throw at the wall and see what sticks. But what are your thoughts on that?
Yeah, well, I don't think this is likely to be a fishing expedition per se. And the reason why is, again, she's not cooperative. So that's a very dangerous strategy to take with somebody. If you not only don't know what they're going to say, but then you also know that they're hostile to you, that's just not somebody that you want to put on the stand, because they can destroy you before you've even noticed. So I mean, there may be some elements of fishing expedition going on, in the sense that this is an opportunity to get her under oath, to pin her down to certain details of what her account is. And then that becomes useful later on, because as you continue to investigate the case, as you learn what other witnesses have to say, what other independent evidence says, and you're presumably getting ready for the trial stage, you have that prior testimony that you can rely on, because you can always kind of force her to come back and acknowledge this is what you testified to under oath the first time. So it gives you that certainty. If you were just doing a fishing expedition, you would just go take her deposition. I mean, that's much easier, I guess, in some ways, to arrange out of state than to, go through this process of compelling her to come back to Idaho for this hearing. What I think is most likely, just from what we have read, is that she's been interviewed, obviously, multiple times, and there have been some things that she has said in that interview that they find helpful. Don't know why, don't know what, don't know how helpful, but just to some extent, it contradicts Dylan's timeline. It, contradicts some aspect of what she witnessed. It contradicts some other piece of the circumstantial case against Bryan Kohberger. They may then build upon that to, see if they can, I guess, find more. But generally, this is just not a great process to be using for those fishing types of tactics, just because it is so easy to get burned.
Yeah, you just said a whole bunch there. No, I'm just saying there's a lot to dissect there. Because I mean, if you really, and by the way, guys, I put up a poll at the top of the chat on YouTube. If you're watching on YouTube, please go over there. If you're not watching on YouTube, please go over to the YouTube chat and put in your poll, okay, or put in your vote. What do you think? Do you think she knows more? I know we did this conversation before, but now we got a professional on that knows the legal, okay, the ways around the legal world. Now that you're hearing a different perspective, I'm wondering if we're going to have a different result. So definitely hit that poll up at the top of the chat. Let me hear your thoughts on this too. I just said, do you think she knows more or not? Okay, it's very, very simple. Yeah, I think she does know, or this is a nothing burger. That's literally the two choices you got, okay? And of course, I'm going to be asking you that here in a little bit too, because of course I got to get your gut reaction on that as well. But when we see this, okay, especially let's get back to obviously this exculpatory information or exculpatory evidence. There's something I got to ask you, and I'm going to go back to some more of those questions, some more of your questions. I promise you guys, we are going to go back, okay? Because I see you guys with a lot of questions. But let's talk about this. Dylan, come on. Dylan's not getting subpoenaed? Mm-hmm. The person who allegedly saw him or saw someone in all black, bushy eyebrows, lanky dude, pretty much a male form. Why isn't she being subpoenaed?
Well, so as far as I can tell at this point, in-state subpoenas are not being made public. And that's often because they don't always need to be filed in court. Attorneys can frequently just issue them themselves. I haven't looked at the specific Idaho procedure for that, but that is somewhat common. So, for example, all of the witnesses, like the law enforcement who's going to come testify, everybody technically kind of needs to be subpoenaed. If nothing else, is just a CYA for the prosecutor in case something comes up. They get hit by a bus on the way to court, and you need to get a continuance. You're going to have to show that witness was under subpoena if you want things like that to be accommodated as the hearing is going on. Dylan Dylan. We don't know if she's being subpoenaed or not. So possible explanations. One is just that she has been, but she's in state. Last I heard, I think she was in Boise. So there wouldn't, be this out of state process that then comes to light, from another jurisdiction to show us that that's going on.
But wouldn't we know by now about that paperwork? I mean, I know that this is out of state and everything, so there's a lot of paperwork going back and forth. Of course, her trying to squash, but given the fact that it's still, even though it's internal, in state, wouldn't we know about her being subpoenaed for this preliminary hearing?
I don't know that we necessarily would at this point, because that's what I'm saying. We haven't gotten subpoenas like that for other types of witnesses that we know for certain are going to be there. Like, for example, the officer that wrote the probable cause affidavit, Officer Payne, all the people who responded at the scene, the people that did the cell phone work stuff, like all of those people are all going to be witnesses, but we don't have subpoenas for any of them. And so we've also seen that a lot of that stuff is being kind of kept under seal, and then it's, being released kind of later on down the road. We had a whole bunch of subpoenas ducis tecum that, had been issued, but, then we found out about them later kind of in bulk. So it's possible that something like that is going to happen as well. But at this point, just because we don't have records of subpoenas for any witnesses for this preliminary hearing, it doesn't surprise me then that, we aren't specifically seeing one for Dylan. It's possible, not unheard of, that if a witness is being cooperative, you would just forego subpoenaing them anyway. You would allow them to, just show up on their own. I don't think that's likely in a case of this magnitude. I think you have to do everything by the book and CYA and get everybody who needs to be there under subpoena. So I do expect that she probably will be, and she probably will be by the state.
She better.
It
just doesn't It would be ludicrous. It would be
Yeah.
absolutely ludicrous if Dylan, of all people, who saw a body allegedly walk through, that would be the most ludicrous thing for her not to be subpoenaed. I'd be like, wait, why? What? Because she might have exculpatory evidence that could exonerate and maybe, of course I'm maybe over speaking here, but and that could maybe set this man free, maybe, or stop this from being a case. I don't know. But it just doesn't make sense that they're going for Bethany, which we've heard nothing from. She disappeared. She's gone. She left the state, okay? And she's the one getting subpoenaed. And I get it being out of state and everything, but for Dylan not to get the same subpoena, if she doesn't get it, it's the most ludicrous thing in the world. We got a few more comments here. Look at this. JDR said the defense is using her as a ploy. Can the defense even do kind of grimy type stuff like this at all before a trial? Can they really do this kind of stuff?
I mean, I suppose in theory, as long as they have a legitimate reason for, a legitimate argument that her testimony is material and that she does need to be there. And they've gone on record under oath that portions of her information is exculpatory. So it can't be a total ploy. You don't get to lie to the court about having, something in your pocket that you don't actually have in order to get the witness present. But they can certainly have mixed motivations for, why they would want her to be there.
Okay. Very, very interesting. I know that, some lawyers could play dirty. Let's keep it real. Some lawyers could play dirty, but I find that very interesting. Like, we're going to bring out Bethany, and what that is, that making the prosecution shiver in their boots. Like, I just don't think so, unless prosecution knows some information that we obviously, the public, doesn't know. That could very well be it. But to use her as a ploy, I don't know. I feel like it's a little bit of a stretch in my personal opinion.
And I'm not sure I understand too what the purpose of the ploy is. I mean, I suppose it's a publicity thing, that this is going to get out in public, that she's got exculpatory information, so it's going to change the public perception on the case. That's just the example I guess I can think of. Right. But it just seems unlikely to me because, somebody had to dig up the fact that this happened. It dates back to March. So it's been going on for a month, and I think it was Sleuthy Goosey who found it in Washoe County. Not all that long ago. So yeah, it just, if this was a press publicity type of ploy, it was extremely poorly executed because it depended on a lot of serendipity for it to come to light in the first place.
I mean, do you think that like prosecutions out here just shiver me timbers? Like, are you really in their boots? Like, do you really think that they're tripping right now over this or anything else that's been leaked or, presented in documents and stuff right now?
The state is very stressed out. I don't think there's really any question about that.
They're always stressed.
they're stressed. This is an egregious case. People are very, very concerned about solving this case, about getting it right. They don't want somebody who's capable of doing this type of thing out on the streets. Yeah. So people are very, frankly invested at this point in believing that it was Bryan Kohberger who committed this crime. Nobody wants to not believe that because that, makes you think of very unpleasant alternatives.
Shiver me timbers.
Yeah, if that's the situation. So the prosecution they're stressed out because there is so much at stake, and there, again, it just kind of always comes back to their case isn't really that strong. It looks good in the collective, but if those pieces start to fall out, then you start to have more and more of a problem. And so, for example, I'll go back to that search warrant affidavit from Whitman County because I'm still waiting to see how this one plays out. They had that disclaimer in it that if the DNA evidence turns out not to be admissible for some reason, then please don't include it in the probable cause determination. Well, why would we be anticipating that? That is a very, very unusual thing to put in an affidavit like that. And the rules for the preliminary hearing in Idaho specifically say if there's going to be evidence that is, that should be excluded, that's not admissible for these reasons, then they can't consider it at the preliminary hearing. So all of this tells me that the state was concerned about the DNA. If the state was concerned about the DNA, that means the defense is probably concerned about the DNA as well. They're probably on it, probably making arguments about it. And that, for example, is such a huge piece of the state's case that if that falls out, your situation, you probably are going to have enough to clear the probable cause bar at that point, just because it's a low bar. But are you going to win the trial without the DNA? That's a really, really tough question. So then there's also all of this other stuff that's still going on in the background that we don't know the details about. The search of the car, all the forensics that they're going to do on that, the towers, the cell phones, the data, all of that type of stuff is going on in the background, and we just don't know what it is yielding or not yielding. So the prosecutor is trying to deal with all of this stuff. He's trying to stay out ahead of it. He wants it to be as smooth and easy for everybody as possible. But there's always going to be even small conflicts, little things that are problems for their case that they just have to figure out how to deal with. So without having that whole picture that the prosecutor has, hard to say how much they're freaking out about this specific issue with Bethany Funk. But just in the general, 10,000 foot kind of view of things, they don't want the defense to have any exculpatory information to be able to work with. All of that is very threatening to the prosecutor.
So I can see them a little perturbed over this information. I can see that. I mean, no matter what, it's still movement in the defense, on the side of the defense. And yes, it is true. This is all right now because of the court of public opinion. We are all looking at this man. I mean, majority are looking at this man and saying him guilty, like he's guilty as hell. But of course, we all have to remember that innocent until proven guilty in the court of law. And there might be information here that could very well let this man free. This could literally exonerate this man. And we have to realize that is a part of the harsh reality of it all too, that they could have the wrong guy. And that's scary to think. But at the same time, those are the breaks if that is the case, One other question, and this is a little bit of left turn, but not really left turn. It still has to do with the case. But it is a damn good question. So I'm gonna pull this up anyway. KG, I was going to say this earlier. So real quick, if Dylan was intoxicated, would her eyewitness still be reliable? That's a damn good question.
It is a good question. Yeah. The only way to answer that question is really, what do you think? Because it's certainly something that can be raised. It can be brought up as challenging her capability to accurately recall, perceive, relate events that she witnessed. So it's an issue. How much of an issue it has on her credibility depends on who gets to make that credibility decision. At the preliminary hearing, it's going to be up to Judge Marshall how significant that is or isn't. At the trial, it's going to be up to the jury to decide how significant that is or isn't. It could be different, because people have different perspectives on that type of thing. You could get one result in one proceeding, a different result in a different proceeding. So that's very much a personal judgment type of question.
Interesting. I got another question. Soothy Goosey's in the house. Hello, Soothy. Soothy Goosey. What the hell's wrong with me? Sleuthy Goosey is in the house. Hello, Sleuthy. She says, can you please ask Andrea what she thinks about the new news that 2 from the Attorney General's office were brought in today after Bill Thompson begged for their experience and resources? Can you expand on that a little bit? Because that's a little bit of news to me as well.
Yeah, so I haven't seen the specific news, but it actually doesn't surprise me. In fact, it almost surprises me a little bit that they didn't do it sooner. That type of thing is not very uncommon at all. I've seen that in different cases that not any that I've worked on personally, but cases that have been going on in jurisdictions where I practice, where a particular case, for some reason, it's so high profile, it's so complicated, there's so much going on with it that it's just beyond the capacity of the small local jurisdiction to really be able to handle it all and still do, their other job of, continuing to run the prosecuting attorney's office for Latah County. So again, given the scope, the significance of the case, how much is going on with it, it's a fairly complex investigation in terms of all the different law enforcement entities involved, all of these different forensic pieces involved. It is a very resource-heavy case. So small county, doesn't surprise me that they'd reach out for assistance from the state. Interesting.
Yeah, that's actually news to me. I didn't know that actually has gone on or went down today, or that's some interesting information, to be really, really honest. Yes, Nini Panini, I agree. This is going to be a long ass trial. I'm going to be honest. Yes. I've heard other things too that people are saying. I've heard like people, pundits and commentators basically say, oh yeah, we shouldn't even be doing a preliminary hearing. It should just go straight to trial. Why are people saying that right now?
I'm not sure. I really don't know. I think, well, and part of it is just a matter of perspective, I guess, on the process. So for example, in Washington, we don't have preliminary hearings. We don't go through all of this. We don't do a grand jury either. For us in our state, it's enough for a police officer to write down an affidavit under penalty of perjury, give it to a prosecuting attorney. Prosecuting attorney gives it to the court. Court looks at it, says, great, that looks good. That's all you need to take someone to trial for a felony charge in Washington. That's we're a little bit unusual that way. Most states do require some kind of a backstop process here to make sure that preliminary determination of probable cause was fair, it was full, it was based on, complete information. And gives the defendant a chance to participate in that. But it's not, I can see how, as a layperson looking at this process, it does look a little bit strange. It looks like you're having a trial before you bother to have the trial. And so, why are you doing that? Well, it's to publicly vet the basis for these charges being brought against him in the first place. It's really intended to kind of validate the decision to charge him. So I can definitely understand, different perspectives on the value of that, but that is kind of the bottom line of why it's done.
Interesting. Yeah, because obviously there's a lot of people that are wondering, like, why is it necessary, so on and so forth. And of course, you kind of answered it, but I'm going to put it up here anyway. Another question Laura just asked, can pretrial end the process and lead to dropped charges? And from my understanding, yes, it could. But if that's got to be some damning, like, solid information or solid evidence to prove otherwise, from what I've understood. What are your thoughts on this? Obviously, I'm just a civilian. What are your thoughts on this?
Yeah, no, I think that's absolutely correct. It is theoretically possible. The purpose of this preliminary hearing is to prove. They have to present evidence to prove they have probable cause to believe Bryan Kohberger committed these crimes. And so if they fall short of that burden, then yes, the answer is going to be the charges are going to be dismissed if Bryan Kohberger is going to walk out of that court. It's just that is, generally speaking, unless, like you're saying, unless there is some big bombshell here that we don't know about, that's a very unusual outcome. Probable cause is not really that high of a standard. It's not nothing, okay? At least I like to think it's not a rubber stamp. Okay, a lot of times it often acts like a rubber stamp, but it isn't nothing. You have to be able to show at least some logical reason to think, this guy should be standing trial on this charge. So they don't have a ton. But from what they have right now, from my perspective, no question, they have enough. The real issue is going to be, does enough of that fall out? And have they gotten more since that initial affidavit that we got to be able to, build up and really strengthen the case more than what we've seen so far?
True. I mean, obviously, regular guy talking here, but clearly, I think that it's rare. I would assume it's rare that you have a preliminary hearing and they're going, well, no, he's free. He's innocent. I feel that it's very, very rare that ever. I don't think I've ever heard of a case ever ending with the person walking out after a preliminary hearing. In my personal opinion, and I'm not a lawyer, but from what I've heard, I've never seen anything like that ever happen. So it would be very, very rare. It would be catching a shooting star, for crying out loud. Literally, impossible. I feel.
I agree. I think it's very unusual. It's usually going to, I think, be dependent on some very specific circumstances. It's going to be like evidence has been falsified, or there's been, false representations that were made in the initial affidavits.
Yeah.
It's going to be something like maybe a material witness has died, no longer available to testify. It could be something like, sometimes it's as simple as the law changes. The law does change, and maybe we're no longer dealing with the standard that police were accustomed to dealing with on some other things. There's little moving pieces like that can affect it, but just a flat out no. I hear your evidence, but I just don't think it's enough. That almost never happens. And that's in part just because, Bill Thompson, he's not a rookie. Okay. He's been doing this for a long time. He knows what the court expects to see. He understands what the standard is. So you can kind of expect that even if it's not the strongest case in the world, it's still going to be enough to be able to get him over that hurdle.
Yeah, like I said, sorry, Precy just said it happened on Legally Blonde.
Yeah, that's right.
Stop it. Stop. Thank you for that, Precy. I appreciate that. The hell is wrong? But yes, so it'd be very interesting to see if it'd be wild. I mean, I feel like, and I said this joke yesterday, but I feel like Bethany would have to go up there and say, instead of it being a tall, lanky guy wearing all black, with bushy eyebrows, it's like, oh, it was a short guy that looked like a mix between Danny DeVito and ZZ Top. You know what I'm saying?
I could have sworn it was Gwyneth Paltrow.
Yes, I mean, it was Angelina Jolie, a supermodel that came into the house, and it was female, and she was Asian, and she had red hair. Like it would have to be something so off for them to be like, does he look like an Asian redheaded supermodel? I think not. Case closed. And it would be so wild.
And not only that, but it would have to be so highly credible that it would rule out, okay, now we have a conflict between, Dylan saw this person and Bethany saw this other person. How do we reconcile this conflict? Does this mean there were two people present? Does this mean that, some person's memory was bad? If some person's memory was bad, why is that? What are the explanations for, this discrepancy? So again, just because Bethany may have information that's exculpatory, she may have said things that are potentially helpful to the defense, it doesn't mean that the court is going to give a lot of weight to that evidence. It doesn't mean that it's going to necessarily be a game changer in this overall probable cause determination. It just means there's something there that is potentially, putting the thumb on the scale in their favor.
Right. This private investigator is basically saying there's something there. There's something there. And whatever it could be, like I said, I don't know. I feel like it's a shot in the dark. In my personal opinion, I really do think it could just be a full-on shot in the dark. She's going to be pulled in there, dragged, literally. Okay, she's going to be clawing, like she's going to be dragged in there, literally, for her to say nothing, I feel. Unless, again, we got to remember, there's a lot of data. There's a lot of information. There's a lot of cell phone stuff. There's a lot of all this other social media crap, everything that maybe there's something more that we don't know about. Maybe, I don't know. I don't want to go into crazy speculation land, but there could be something more going on that we really don't know about. And the fact that they say that allegedly, from this private investigator, he's saying she heard things and she saw things. Whatever she saw could be huge, but then again, it could be absolutely nothing as well. We got another comment here. Iris, thank you so much for the comment. Do we know for a fact it's defense who has subpoenaed Bethany? Can it be a judge?
Yes, we know for a fact it's the defense that has subpoenaed Bethany because the judge is not a party to the case. The judge is not going to be making any decisions about who should be compelled to testify or not to testify. That's for the state and the defense to figure out, because they're the advocates. They're the ones that are. That's really their responsibility is to figure out what the evidence is and get it into the venue. Her job is just to figure out if it's admissible or not. In some limited circumstances, like with this certificate, she may need to facilitate that process for them. But she's not going to be the decision maker for that type of thing. No, it was 100%. It was Bryan Kohberger's team that decided it.
Definitely Bryan Kohberger. So that you guys all hear that, okay, from Andrea Burkhart, okay, from her. Came from defense, just so you guys know. Yeah, it came from the defense side. They think that they got something. They feel like they got something. Whatever it is, we don't know, but they got something. And it could be everything, and it could be nothing all at the same doggone time. Okay. Let's see. Hold on. Sorry. You know what? I'll pull this one up too. Julie, Rob said, it is interesting. He said, eager to be exonerated. Coincidence?
I mean, it's a common word.
I every time I get out of the shower, I exonerate myself from the shower. You know what I'm saying? When I wake up in the morning and get out of my bed, I exonerate myself out of the bed.
I need to do it like you're doing it.
I do it every day. It's common every day, but yes, I do think that's interesting. It is a coincidence, but at the same time, this could be literally a shot in the dark. His team brought in a private investigator to go and lurk around. Okay. He lurked. He found something, whatever that might be. It could be big. It could be small, whatever it is. It's a shot in the dark. In my personal opinion, I think it's a shot in the dark. There's a lot of things pitting up against Bryan Kohberger right now. Mm-hmm. He's got this one thing. And I know, I get it. Let's not forget, okay, we got a knife sheath. That's it, with a thumbprint or whatever, some DNA, whatever it may be, whoop-de-woo, right? But we still have all the other stuff, digital evidence, the cell phone data, all this stuff. They even took his Fire Stick, y'all. They got something against him. And there's a digital breadcrumb path towards that house. The only issue that I have, and I keep saying this over and over and over again until I'm going to be saying it till I'm blue in the face. That's still the only argument I say, the only pushback I have that I feel like the defense has is that they can throw in reasonable doubt because they do not have him at the designated place, at the designated time, doing this unthinkable act to 4 individuals. They still don't have him in the space unless his cell phone connected to a Bluetooth while he was in there or a printer or something like that. We have yet to hear anything of that right now. So defense does still have some things in their favor, regardless if Bethany saw and heard things or not. They have a few things, but one thing they still can lean on hard is reasonable doubt. And that's crappy, especially for the people out here, court of public opinion that is sitting here on the side of him guilty, like me. I think he's guilty, but reasonable doubt is a huge factor here. What are your thoughts on that?
Well, I think absolutely. There's going to be a lot of ways that the defense is going to try to undermine the information that is out there that's public about this case in order to try to raise those types of questions. I did a video on my channel just to kind of briefly talk about the cell phone forensics, for example, just because that's one of these things, a lot of people hear, forensic evidence, think it must be really strong and stuff like that. No, there's been a crisis in forensic science for decades now. There's been like big national reports and presidential commission back during the Obama administration did a huge report on just how terrible a lot of this stuff is. It's a lot of it is essentially pseudoscience. It's never been validated. It doesn't have any type of verifiability. It's subjective processes, that type of thing. So there is typically a lot of just hay that can be made with some of this technical stuff that on first glance might look like, oh, that makes it a really strong case. But once the defense can sink their teeth into it, they're able to show actually, the inferences that you're able to draw from it may not really be all that strong. So they're going to be working on that type of angle. They're going to be working on any grounds to challenge any of this evidence. If there's a reason to be concerned about the DNA potentially being suppressed, defense is going to raise it. Okay, they're going to litigate that, because if they can get that DNA thrown out, that is huge. Okay, that's a big move in the defense favor if that happens. Having said all that, reasonable doubt is still a long ways down the road. Reasonable doubt's not going to be a consideration at this preliminary hearing. The preliminary hearing is based just on probable cause. A reasonable doubt is, much, much higher standard. So at least to the extent that people want to see Bryan Kohberger brought to justice, brought into that trial proceeding and let him have his opportunity to try to show reasonable doubt. That is still quite a long ways down the road.
Yeah. Oh, yeah. I mean, it's a while from now, and of course, there might be more information that unearths here. I mean, we have
to expect that there's going to be, just in light of everything that we've seen about the continuing investigation, and that's just what's come to light so far. The search of the apartment, the search of the car, the search of the parents' home. There's all those kind of weird notations that we're not necessarily really sure what they mean. Yeah, ID cards, that type of thing, may or may not be significant. Obviously, a drop of any of the victim's blood in his car, potentially a game over. All of those types of opportunities are still potentially out there that, of course, will make it that much harder then for the defense to explain away to be able to get to reasonable doubt.
Yeah. And that's absolutely true. I mean, obviously, there's still a lot of more information that we still don't know from the car and all the other places that they investigated. They are combing through so much stuff. But that's the thing, too, the ID. Real quick, the ID that they say was from someone in the house. What do you think? I mean, because they say that there's an ID. It's from somebody in the house. It was in a box. It was in a glove in a box in his car. Now, why would he have an ID of whoever from that house on his person? That just seems a bit odd, don't you think?
Yeah, it was a bit odd, and I wanted to pull it up just so that I could see exactly what it had said, but I don't have it.
And wouldn't
have
you
it exactly right offhand?
And wouldn't you consider that smoking gun evidence?
Well, the thing is that it's not that clear. Okay, the warrant return said something like ID cards in a box, and I believe this was from a search of the home, of search of the parents' house, because it was with the other things that they had taken from the home, like his clothing, laptop, stuff like that. And so there has been, my understanding, subsequent leaks or, anonymous sources type of stuff that have tried to fill in some of the gaps on what these ID cards are. I look at all of that type of information and reporting at this point with extreme skepticism. In fact, personally, for the most part, I'm just avoiding most of that right now because it simply isn't reliable. It's not credible. We've seen so much of that fall apart already. For example, with Cara Kernodle and the whole issue with the conflict of interest that turned out to be a non-story. Because, none of what had been reported about that previous relationship ended up being true. So what those ID cards are, don't know, could certainly be a smoking gun. Absolutely. And, that's going to be difficult to explain if that's the case, but could also be potentially innocuous. We just don't know.
I definitely could see, his lawyers being like, explain this. And he's like, well, okay, see what happened was, and just fumbling through the whole thing, trying to explain this.
Yeah, what you find, at least what I have found with working with a lot of people in the criminal justice system, you are dealing with massive amounts of denial. And so you just kind of assume there's always going to be an explanation for something. It reminds me a little bit of when we watched the Johnny Depp trial, how Amber Heard literally has an explanation for absolutely everything. And she's convinced, that everybody's buying this and that this is airtight. She has locked it all up, and there's no other possible way to see things. But just that perspective tends to be limited to that person. So most other people looking at the situation would be like, well, Bryan, that's an enormous coincidence that you're asking us to accept in light of all of these other circumstances, like your DNA, like the cell phone tower, yada, yada, yada. The more coincidences like that there are, the more really it's just adding to the circumstantial case. The more circumstances you have to explain away, the less it looks like this is maybe just an innocent misunderstanding.
I guess I'm wondering how it could be an innocent misunderstanding. Just randomly having one of the roommates or one of the residents in that house ID in your car in a glove, just chilling. It just seems a bit odd. And I know that there's theories that it could be maybe Dylan or Bethany's ID, maybe has nothing to do with the 4 that were taken in this grisly way. But still, it'd be very interesting to hear what his explanation, right? It just fell in there. I don't know. It just randomly showed up. It just materialized. But then that I keep thinking about, and I want to tap in on this too. I know we talked about the Brady Giglio situation. But I know that we have a law enforcement that was feeling a lot of pressure. People were breathing down their necks. Media, everybody, social media, YouTube, everybody was breathing down their necks going, we need results. You need to show up with results. You're not telling us anything, and you're not presenting anything. You're not presenting any movement. And then out of nowhere, Bryan Kohberger is the new guy, right? So I know that there's some people thinking that, at least that's been out here, that maybe they slipped the ID or they're planting pieces of evidence to make him look like he's the bad guy. But the only pushback I say about that, because we already know that Ann Taylor has exposed law enforcement before, okay? Apparently she's a good lawyer. Yay for Bryan, I guess. What are the chances of this happening again? Cops doing something, manipulating, because we already have a Brady Giglio going on here, and we don't know exactly what it pertains to, but we do know it exists. So it does make you wonder, where's the corruption, and is it that deep?
Well, I mean, boy, that's really a big door to open.
The $1 million question, really, right? It's the $1 million question.
It is. I mean, yes, that's the question. How deep does it go? And okay, so something to remember too, at least with Brady Giglio stuff, it isn't always deliberate. Yes, sometimes it is, but it is also the case that sometimes mistakes just do happen. Things get overlooked. Prosecutors, for example, are responsible for all of the information that is in the hands of the law enforcement agencies that they work with, the labs that they work with, and stuff like that. So even if they don't actually know personally, the lab could keep stuff from them, and the prosecutor doesn't know that, but the prosecutor is still going to be responsible for that. It's going to be imputed to him in this Brady Giglio situation. So there's a lot of these situations that there are problems procedurally because they're not supposed to work this way. Obviously the legal system is not supposed to work to suppress exculpatory evidence for the defendant, but it isn't all entirely, corruption at stake. Now, having said that, a lot of it is, and I just got to, again, kind of go back to that search warrant affidavit and the big red flags that it has in there about the DNA. You know, if the DNA isn't found to be admissible, there's a couple possible explanations for that. One explanation is that, you know, whatever procedure they use to do the DNA testing or something like that isn't reliable. It's not going to be considered sufficiently like scientifically established to use it in a courtroom. That's possible. But the other possibility, and one that, you know, as a defense attorney, I'm used to looking for, spotting these issues to follow up on a brief and stuff, is that the manner in which they obtained it was not legal. We know they didn't have a warrant for it. They went and got it from the trash. And so something kind of my speculative theory about this for some time has been the possibility that this is a very fine legal distinction, so bear with me. But when the trash is in a bin at the curb, it is considered abandoned. But if the trash is in the bin and it's still up by your house, it's within what is considered, it's called the curtilage. And it's the area that's so connected to your house that you would expect it to get the same kind of privacy protection as your house, right? So somebody walks around to your backyard and, you know, peeks in your windows, they're in the curtilage of your property. You have a reasonable expectation that they're not supposed to be there and they're not going to be doing that.
Interesting.
So possible explanation for it. Again, this is hypothetical and I have no proof of this, but it is just what first jumped into my mind when that news came out is, wonder if police went up to the house to get it out of the bin. They entered the curtilage. That's going to give you grounds to file a motion to suppress, and it's potentially going to be a strong motion. So things like that happen. Corners get cut, you know, rules get broken, rules get bent. Personal opinion, tend to see some of that stuff kind of happen a fair amount when the FBI is involved in your investigation. Just you know, matter of personal opinion. Just going to put that out there.
So just cutting corners, you know. That's interesting because curtilage, I just thought it was, you know, expired milk or something. But that's good to know that is true. And then apparently another man's trash is another man. One man's trash is another man's treasure. Is only if it's on the curb of the road, but not on their property. Okay, now I get it. Now I get it.
If you haven't taken it down to the curb yet, you have not necessarily expressed your intention that anybody in the world, you know, whether the garbage man or whoever else could come out and pick through it. When it's still up by your house, you're expressing that this needs to be treated with the same respect as everything else on my property. So that means you need a warrant for it.
Dang. So that dinner table that I took last week off of somebody's driveway, they were having a picnic. I didn't realize that until just now. Oh, wow. They were having a picnic. I just straight up took it. My bad, guys. I owe you guys a dinner table. But that's interesting to know. No, that real talk, all jokes aside, that's very interesting to know because, but that's like that's red tape BS, right? I mean, you see some DNA, you see some DNA. It's right there outside. Like, I'm just saying, it's outside. Yeah. It's not on the curb so much. It's not on the street, but it's right there. And you see it, and you're like, oh, wait, there's a little blood in there. That looks like a little droplet of red in there. We gonna grab it. Suddenly it's no, technically that's curtilage.
It's no, if it is within the intimate, like areas intimately associated with your house. And that can be a factual question. You know, if it's halfway down the driveway, you know, they started taking it to the curb, but didn't finish. What does that mean? Well, the judge is going to have to sort that one out.
Yeah.
But you know, if we're going to make it black and white, yes, if it's at the curb waiting for pickup, the police can go through it, no question, but it's up at your house, they can't. And it may seem like a red tape issue, but this is a Fourth Amendment. This is part of our privacy protections. You don't want the door to be thrown open for the police to be able to come up and peek through your back windows while you sleep at night. You know, that's just not the kind of world we live in.
But you're telling me that this is during, okay. So when did they obtain said whatever that was in that trash inside of this house? I thought that they were doing a search anyway. So what, the warrant didn't last?
This was the warrant. This was the seizure that they did in December. That they got the trash and then derived the DNA that they are identifying as being essentially Bryan Kohberger's father and having that match to that familial match to the DNA sheath. And that's the point then when they got their formal arrest warrants, they got their formal search warrants and stuff like that. So it preceded that process happening. They didn't have a warrant to do it, and it was kind of the final piece that prompted the more aggressive moves that they then made.
Now I get it, because I lost that part, and my bad for everyone that's totally with her and is totally caught up. I got lost there for a second. I'm like, how? If they already were searching and they just grab it, it's already, search warrant has already been implemented, or is in full effect. But now I get it.
And they may be able to cure some of that. It's just it becomes very complicated, because if that piece of the puzzle falls, it potentially undermines those subsequent warrants, which is why they were so concerned about it in Whitman County. Because if you can then go argue you shouldn't have seized any of this stuff because it was predicated on this illegal seizure that you did in the first place, oh boy, that's a mess. That's a big mess.
Okay, so if it's a big mess, please explain the big mess. How can it be a big mess? Are you saying that just that alone, forget Bethany, forget any other eyewitnesses that say, a short Danny DeVito / Asian female redheaded supermodel was in the house? Can they sit there and say, well, because of this, because of this violation, because of this Brady Giglio thing, we got to throw everything in the trash, like literally throw everything in the trash?
Yeah.
Could they just basically have him walk because of that?
So the way that it works is that if police do something illegal, they do an illegal seizure, an illegal search, something like that they're not supposed to do, then that triggers what's called fruit of the poisonous tree rule, the exclusionary rule. And it just basically means police don't get to break the law and then exploit that to get evidence that they use to prosecute you. So anything that is reasonably attributable, directly attributable to them having committed that illegal act, that's going to be suppressed in court. And that is for the purposes of deterring police from doing this type of illegal behavior to try to get ahead in their case. So it wouldn't throw out everything that they got that led up to the point of that potentially illegal search. But if they did conduct an illegal search, then pretty much everything that depended on that is going to be challengeable. There can be exceptions for. Sometimes the state can argue, well, we were going to find it anyway because of X, Y, and Z reason, or we had an independent source that brought us to this point. We didn't necessarily have to exploit that illegal search to get us there. But now you have the state on the back foot in the defensive position trying to get this evidence in, which is, not at all where they like to be.
Yeah. So I guess that'll be interesting to see as time goes on as well then, right? Just only be on that?
I have to assume that there is going to be a motion to suppress the DNA evidence. The only reason, again, I'm assuming that is because they told me in the warrant affidavit that I should anticipate that there is at least enough reason. If the police can anticipate a reason that it might be thrown out, then the defense is probably going to anticipate that reason too. So I do expect that there's going to be a motion to suppress. We probably aren't going to see it just because, as we've seen, so much of the stuff is being sealed until, more of the process is underway. But I would expect by the time of the preliminary hearing, we're going to know one way or another at the preliminary hearing if they can use that evidence or not.
Interesting. Oh, my Lord. And if they can't, damn. Because I mean, because that is the evidence that brought them to him. Right?
It's by far the strongest individualized piece of evidence that they have, no question, because without that, they don't have a match for the sheath. They're going to have to say, okay, we can go back and independently get Bryan Kohberger's own DNA and do the match. We can just take the trash piece out of the picture. But the problem is you relied on the trash to get him arrested, to get the search warrant for his DNA. So that's going to be tough.
So, so that's what I mean by So if they say, well, can't use that, then he can go, because that's the only reason why he's there. Like literally, that's the only. Sorry, go ahead. Sorry.
Yeah, I mean, potentially.
What the hell? What the hell?
So my personal perspective,
That's insane.
without the DNA, they still have a circumstantial case, but it's extremely weak. I mean, are we going to clear the probable cause hurdle without the DNA? I just really don't know. And at this point too, it depends on, what else have they been able to find, and is any of that going to be viable as well? Is any of that,
Right.
attenuated or whatever from the problem with the trash? So
I mean, fingers crossed, right? I mean, but it all depends on what they decide in court, right?
yeah,
What
it
the judge
depends on
decides.
it depends on what they decide in court. Obviously, this is pure speculation on my part. I have no reason to think this is actually the case. This is just the first thing that popped into my mind when I first saw this issue of, potentially there being an issue with the DNA. That's where my mind went, is, oh, there was a problem with them getting it out of the trash. But it is definitely possible it could be something else, and that, whatever it is not the kind of issue that, has these downstream consequences the way that an illegal search is going to have.
Interesting. Okay. Well, I mean, yeah, that's just theory, just speculation. It's a hunch. But man, if that's the case, that would be really, really bad. That'd be terrible.
It would be very bad.
Very, very bad. Leanne, thank you so much for the 10. I think she had a question. She said, dang, I forgot to type the question. So I think this is the question. Leanne, thank you so much for the 10 super chat. Okay. So didn't they send the trash to Idaho for testing and have the results in less than 24 hours?
Yeah, I don't remember if they sent it to
Neither do
Idaho, but I do remember that they had the results within 24 hours. Very quick turnaround job on that one.
But then didn't they send it out to another independent lab because they I guess they didn't get what they were looking for there, so they sent it to another lab, and then they ran whatever they needed to run over there, and that's where they were able to find a little bit of Bryan Kohberger on that knife sheath.
I don't remember 100% for sure. They said, okay, here's what the PC affidavit says. It says on December 27th, 2022, Pennsylvania agents recovered the trash from the Kohberger family residence. That evidence was sent to the Idaho State Lab for testing. On December 28th, 2022, the Idaho State Lab reported that a DNA profile obtained from the trash and the DNA profile obtained from the sheath identified a male as not being excluded as the biological father of suspect profile. So it doesn't say specifically that it got sent out somewhere else, but that is possible. The Idaho lab could have, basically subcontracted with somebody else, either to do, the testing on the kind of accelerated basis that they apparently wanted it, or because there were techniques that the other lab could perform that the Idaho State Lab could not perform. It's written in this, somewhat passive language that would allow that to be possible without really, coming out and directly saying it. So can't say for sure one way or the other.
Interesting. And yeah, correction. I had the sheath in my head. The sheath was tested in one spot, then sent to another place. And then that's when they were able to find, like they sent it to an independent lab. That lab was able to find something on the button of the knife sheath, and then of course Bob's your uncle. But we got to get into this next piece just really, really quick, and because I don't think it's that big of a story, but it is something that is what is circulating out here as of the past 24 hours. Court denies request to lift gag order in Idaho murders case despite well-guarded rights. So of course, let me just read the first paragraph here really, really quick. But the Idaho Supreme Court on Monday rejected a request by 30 news organizations to lift the gag order in the criminal case of a man accused of, we already know, of, in the Bryan Kohberger case, in the Idaho 4 case as well. Okay. The high court did not weigh in on whether the gag order, which prohibits attorneys, prosecutors, law enforcement agencies, and others involved in the case from talking to the news media, violates the First Amendment rights of a free press. Sorry. Instead, The unanimous Idaho Supreme Court justices said the news organization should have brought their request to the magistrate judge who issued the gag order. Tell me your thoughts on this. It's very interesting. 30 news organizations said, please lift it. So I want to hear your thoughts on this for sure.
And the Idaho Supreme Court said, solve your own problem.
Yeah, figure it out, guys. Figure it out.
I mean, this just comes down to, something of a procedural issue. They were asking for a writ of prohibition, a writ of mandamus, which is, ordering the lower court to do something. And that is legally considered an extraordinary remedy. You don't get that very often. It's a very limited set of circumstances where that's going to be appropriate. And so the fact that they had not bothered to go and ask the judge who had issued the gag order in the first place if she might reconsider it, that's a problem for the Supreme Court. It doesn't, if you have potential remedies available to you, then you don't get to, you're not so important that you get to jump straight to the Supreme Court, to get us to give you this extraordinary relief. You're just like everybody else. You have to follow the same processes. So yeah, I think now this is going to go in front of Judge Marshall. I think that seems likely, and frankly, from my perspective, I think that's appropriate because she is the one who is in the position to, if it needs to be modified, she knows what the concerns are with the trial. She knows why, there are concerns about stuff being made public. She's much closer to that situation than the Supreme Court is. So she's in the best position to be able to weigh, here's what the competing interests are. Here's what I'm trying to accomplish with this order. Maybe it's not working for one way or another, so we can just tweak it or something like that. But basically, there's just a lot of ways that this could potentially be solved short of, just getting this top-down mandate from the Idaho Supreme Court that's remote from the problem.
I'm going to say, yeah, they are going to have to jump through hoops and try to make that be lifted, this gag order be lifted. But I'm going to say it. I'm going to say it out loud. And I know it's probably unpopular opinion, and I don't care. I'm okay with this gag order. I'm just going to say it. I'm actually saying keep it on. Keep it until the trial. Everyone shut the hell up. That's what I think. I think that look at the amount of BS that we've been hearing from sources all day long. We even heard from sources that Bethany was not there and had nothing to do with it, didn't see nothing, didn't see the carnage, wasn't a witness to anything. And now we're hearing something possibly completely different. The amount of rumors, the amount of BS that's been out here, man, if news jumped on this, it would be first off, it'd be a feeding frenzy. Second, it would turn so tabloidy, so bloody fast to the point where we wouldn't even know what's the truth and what's real, or what's real and what's fake. Sorry, that's what I meant. What's the truth and what's real is the same thing. Moving on. So I'm for this. I think that because no disrespect to the family's victims, the victims' families. I'm sorry, but there have been a few family members that have been very vocal out here. Understandably, they want justice. They want this information, but people are taking it and dissecting it and chopping it up and flipping it and all this stuff. And then it turns into more chaos instead of actually getting the justice that these 4 kids rightfully deserve. So for me, I'm going, hey, I don't need to hear anything until we go to the trial, because that could be damning. That could be damning for prosecution. That could screw everything up. Somebody misspeaks. He misspoke in this one moment. Suddenly they go, what does it mean? He could have gone upstairs. What does it mean? And then everyone goes, oh, no. She was the target. It's like, yo, guys, time out. Chill. Tranquilo. Let's just wait. Let's wait for the trial. Let this gag order be here. I'm with it 100%. Because of the chaos. Before, I was like, damn, this is BS. I want to know more. I want to know the truth. But now that just from the information that we've received from just sources, it's just gotten so sloppy.
Yeah. Well, the thing I think that some folks haven't really considered, which is good because they're not lawyers, and nobody should have to think like a lawyer if you don't have to. But every time somebody makes a statement in the press about, like, this is what the police told me, or this is what the coroner told me, or this is the information that I got, they're potentially helping the defense. Those are potentially prior inconsistent statements that can be used as evidence in these proceedings. They can be used to challenge what the coroner, if the coroner gets on the stand and testifies, I said X, Y, and Z, and you have, a press article where somebody claims the coroner told them something else, you get to call that person in, to testify. This is what I told the press. This is what this person had told me. You're just giving them a lot of ammunition to be able to poke holes in the case. And especially when you're talking, when you're in court under oath, most people do tend to take that quite seriously. You're aware that this is not a situation to be speaking casually about stuff. You're warned, like, be careful, be thorough, the truth, the whole truth, nothing but the truth.
Right.
If you don't know, say you don't know, that kind of thing. But when you're just talking to the press casually, shooting the shit, you could say anything at all and have no idea that it could have these types of repercussions down the road.
Exactly. And I understand that it's a double-edged sword. Like Amanda just said, lack of information is the problem. Well, maybe media needs to stop digging for a little bit. Let this story sit for a little bit until the preliminary hearing, when we get maybe a little bit more information, or wait for documents to come out, rather than it being a source close to the case said. It's a double-edged sword, guys. It's absolutely a double-edged sword. I'm sorry, but don't get me wrong. Because of lack of information, people are getting idle minds. Okay, I know that's not the devil's. Well, idle minds is the idle hands is the devil's plaything, but idle minds in this situation is the devil's plaything. People start exaggerating. People start saying random rumors, throwing out all this BS that's not true. I get it that lack of information is the problem, but at the same time, we also got to understand that, hey, there are plenty other stories to talk about. There are plenty other cases and other missing children, missing persons, people who have been taken against their will, unjustifiably out here in these streets. We could be talking about those and occupying our time with those while defense and prosecution builds their case, so that when we go into this trial or this preliminary hearing, we hear some things. And then a year from now, we go into the trial. Let me say this again. Let me say this too. Let me just say this really, really quick, because I know there's going to be pushback, because I know everybody's obsessed with this trial, obsessed with Bryan Kohberger. Some of y'all waking up, Bryan Kohberger, in the middle of the night. I swear to God. But think about this, okay? We got a whole other year, possibly, y'all. A whole other year. How long are we stretching this conversation out? How long are we stretching this out, y'all? Think about that for 1 second. As soon as that preliminary hearing happens, we're all going to sit there and you're going to hear crickets, because we're all going to be like, what? Twiddling our thumbs. What do we do? What do we do now? Just saying. Just think about it for a second. It's going to be another year. Maybe. Maybe two.
Could be more. Yeah.
It could be more. Yeah. You never know. So I say, let it be what it is. Wait for the preliminary hearing to happen, or better yet, in between time, when they come out with more documents like we're talking about here, this is solid stuff. This is solid evidence. It's not rumor mill. It's not a person saying this down the street, saying something, this, that, and the third, and it's being leaked out here. You know what I mean? You're looking at documents. We're looking at paperwork. It's solid stuff, which is worth the conversation. But as soon as that preliminary hearing happens, even Andy Potts said, I disagree. He walks in June. Hey, if he does, I'll be flabbergasted. Okay.
Yeah.
But I don't think it's going to happen. But even so, whether he walks or he doesn't, what are you going to do during that time? For a whole year, you're going to talk about what? I'm just saying, wait, but that's just my opinion. That's just my opinion. I love y'all. That's just my opinion. What are your thoughts on that?
Yeah, I mean, I think it's difficult because again, just given the type of the crime that this was, it's very understandable that people want to understand it.
Of
People want
course.
to have answers, as soon as possible. But the whole reason we have the trial in the first place is because when you have this sort of serial leaking of information, it makes it very, very difficult for there to be fair decision making about it because the part of the instructions that the jury is going to get at the trial is that they need to keep an open mind until all of the evidence is in. This is the opportunity to put it all out there so that you have the full picture and can base your decision on that. The problem is if you're just getting little pieces along the way, something catches your attention and you're like, oh, DNA on a knife sheath. Well, that's it. I'm done. He obviously did it, and you're then going to be closed off to new information that could come out at a later point in time that could potentially undermine that could be it's not his DNA, or there's an innocent explanation for the knife sheath, anything like that along those lines that could be inconsistent with him being the murderer. So very, very important to have the open mind and let the process play itself out, largely so that you can keep yourself unbiased, as much as possible, and make sure that you have the full picture before you're passing your judgment.
Yeah. Yes. And I get it. We are all very passionate. We're all emotionally attached to this story. We all want justice. More importantly than anything else, we just want justice, and we all, like you just said earlier, we all want to understand what the hell happened here. How did this happen? And was he the only one? Is it him? And if it is him, how did he do this by himself so quickly? So on and so forth. But one piece I do want to point out, though, too, I saw this earlier, and the video. I actually saw the video earlier today, and I said, what? Okay, so, Kohberger is the expert in his own field. No matter what News Nation, it says, calling him with a burner phone. So Ashley Banfield was on her show yesterday, and she was talking about, I guess, Lori Vallow is, had a burner phone or something like that. She had phones, and she was calling people, whatever. During this thing, she goes, who else has burner phones? She goes, drug dealers, whatever, but people who are up to no good. She goes, I got a burner. I got a burner phone. But who else? Who out here? What normal person would have a burner phone, right? So then later on in the conversation, she says, yeah, I have a burner phone, and I've been trying to contact Bryan Kohberger with this burner phone. In my mind, I'm like, wait, is he the source? Is he the source that she's getting all this information from? Like, what the hell is that all about? That's a little bit odd, don't you think?
It tells me that she is aware that her tactics are not particularly appreciated, and she doesn't want them to be able to be traced back to her in a documentable way. That is why, as she says, you use a burner phone when you have something to hide.
But she said it out loud on her own show.
And that was dumb.
That's dumb as hell, right? Thank you.
Why the hell would you say that?
Why would you say, you know what I'm saying? Make that make sense. You know what I'm saying?
What that tells me is that it has not been fruitful. It has not been productive, because if it was working, you wouldn't say anything about it. You wouldn't blow your cover.
Right? She's like, oh yeah, I've been calling him, trying to get in touch with him. I'm like, why would you why would you talk about having a burner phone? Like, what, you trying to tell people that you for the streets? Like, what is this all about? Explain this to me, Banfield.
Yeah, deniability. It's about deniability. And part of that is because they, News Nation is, cutting it pretty close with a lot of their reporting, a lot of stuff there that's not going to be, it's not going to make the court happy. and something that the folks at News Nation would do very well to bear in mind if they're, planning on sending anybody to the preliminary hearing in Idaho is that Idaho doesn't have a reporter's privilege. They can be subpoenaed and compelled to testify about who their sources are. So, all of this reporting about the anonymous sources and stuff like that, as soon as they set foot in the state of Idaho, they may be potentially able to be compelled to give that up. So, not very smart move on their part, in my opinion, but, they get to decide how they want to run their shop. And I get to decide that I will watch my news literally anywhere else.
Yeah, exactly. Right. You can always just not watch. Right. But very, very interesting information. But anyway, I appreciate you coming on and chopping it up with us. And just getting down to the nitty gritty of all this stuff that's been going on, because there's a lot of chaos. And there's a lot of legal stuff that I don't know anything about. So it's nice to have an expert on to explain to us civilians out here, us regular folk, about what's really going on out here. So Andrea, I want to say thank you so much for being on. I really do appreciate it, sweetheart.
Well, it's my pleasure. I really appreciate getting the chance to, take some of my experience and what I've learned over the years and help people understand the process a little bit better, because it is a very important process, one I believe in very strongly. And so I want people to be able to, not see it as something foreign and complicated and difficult. There is a lot of common sense to it. So
yes,
do my best to try to share that.
Oh, and you did a great job, in my personal opinion. Don't you guys agree? Definitely hit that like button down below if you really did appreciate our conversation and her job in explaining everything to us in the best way she can. Also, guys, please go over to her YouTube channel. Okay, hit that subscribe button over there. Show her some love. Okay, check out her most recent video and please let her know that I sent you, that the Pascal Show sent you over to her show. Okay. But Andrea, again, thank you so much for being here. I really do appreciate it. And of course, we'll have you back on again soon, I hope.
It's always a pleasure. We'll do it again for sure.
Absolutely. Talk to you soon, sweetheart.
Okay. Bye-bye.
Bye. So guys, that is the show. Okay. I appreciate all y'all for being here. Hopefully we explained some things. I know that this is kind of like a day or two kind of late with everything, because there's been other shows that have been talking about this stuff and everything as well, explaining these things. But we got one of the best. We got one of the best to come in here and fully explain it, break it down for us. And that's what I wanted. I wanted somebody really good to explain everything. And for a fact, Andrea comes in with the heat and the knowledge. Okay. So again, I need to say this again. Please go and subscribe to her YouTube channel. Here it is again. One more again. If you just put in @aburkhartlaw, one word, you can find her right there. Find her over there. You can find her on Twitter as well. Okay. Follow her. All right. She's a hardworking woman. And she's doing some really, really great things. And of course, you've seen her a couple times on this show, and hopefully she'll be back on a lot more often in the near future. So I appreciate you guys for being here. It does mean a lot again. Okay. On the selfish level, does mean a lot. Thank you. Okay. So please do me a favor. Hit that like button before you leave. Okay. Send it past 400 likes before you head out, because a like don't cost a thing. It helps with the story, helps with the show getting out there into the algorithm. And of course, if you haven't done that as well, hit that subscribe button. Also, I'm going to say this too, really, really quick. I will be on my other show, okay? The Real Beef with S&P at 7:30 p.m. Central Standard Time. So just in a couple hours, I'll be back on again with me and my sister out here chopping it up and talking about things that are going on in the world as well. So please go over there. If you enjoy me, you're definitely going to enjoy my crazy sister as well. And our conversations get totally off the hinges. It's going to be fun. Be sure to tune in tonight at 7:30 p.m. on The Real Beef with S&P. Definitely go and check it out. And please hit that subscribe button over there. We're going into our second show ever, and we're trying to expand and grow this the channel with as many subscribers and all that as we can. So please go over there and subscribe to the channel as well. Anyway, guys, I appreciate all y'all. It's time to get going. And I'll talk to you guys in a couple hours on the other show. 7:30 p.m. Central Standard Time. Be there. The Real Beef with S&P. Be good to yourselves. Be good be good to yourselves. Be good to one another. Have mercy. And I'll see you guys in a couple hours. This is the Pascal Show. Bye.